All right, turning now to the race for the White House and the state legal challenges aiming to keep former President Trump off of primary ballots next year over allegations tied to January 6th. The Colorado Republican Party is asking the U.S. Supreme Court to overturn a state ruling earlier this month that disqualified Trump because the state court found he violated Section 3 of the 14th Amendment, which bars people who engage in insurrection from holding office. Meanwhile, Michigan's Supreme Court rejected a similar effort to remove Trump from the state's ballot. That court said it was not persuaded by the argument. To break it all down for us, let's bring in NBC News legal analyst Danny Cevallos. Danny, good morning to you. So let's start off in Colorado. The state's GOP going to the Supreme Court about this. I think under the current terms, he will remain on the primary ballot during this period. What will Republicans argue to the Supreme Court if they decide to take the case? What will they argue to the Supreme Court?
They have a number of different arguments, one of which is that the president is not an officer within the meaning of Section 3 of the 14th Amendment. Recall that the Colorado lower court concluded that, yes, he committed insurrection, but no, he's not an officer within Section 3. Therefore, even being an insurrectionist, he would remain on the ballot. The Colorado Supreme Court simply held opposite on the issue of whether he was an officer. The other argument they have, for example, and they have a few, is that Section 3 requires animating legislation. That sounds a little weird, but I'll give you an example. You're too young to remember Prohibition. I remember Prohibition. But you'll recall those amendments by themselves did not create Prohibition. There was a separate act of Congress called the Volstead Act that actually enacted Prohibition. So the question here is, does Section 3, does it by itself create this prohibition on an insurrectionist, or does it require Congress to enact some legislation, some further law to actually bring that section to life? And that's another argument the Republicans are making here. Interesting that both of those arguments can proceed even if Trump was deemed an insurrectionist after an evidentiary hearing at the Colorado's lower court, trial court.
As far as the Supreme Court goes, I've never heard something exactly like this before. Do you think that they will take it up?
I think they're likely to take it up. I mean, if I were to give you percentages, they have to be in the 90 percentile because not only that, you have other states arriving at different conclusions. Now, the Supreme Court can say, well, that's fine. That's the way federalism works. Those states have their own laws. They have their own systems. They decide who gets on the ballot. But in a federal national election of the president, that obviously implicates constitutional issues, federal law issues. So very likely, I think they're going to take it up. I mean, I would love to say absolutely, but I can't commit myself to that because there's that tiny chance they might not.
Do they actually want to take it up, though? I feel like they might want to pass on it as they have other recent things in the past.
Generally speaking, the Supreme Court will try to avoid deciding issues of state law if there are what are called adequate independent state grounds for the lower court's decision. However, in a case like this, because it implicates federal law, because it implicates the U.S. Constitution, likely they will have to take it up, even though they might express a preference for allowing something that exists on adequate state grounds to remain as it is.
Fascinating to follow. Michigan, let's talk about them. Different situation there. The request to remove Trump from that state's primary ballot, that failed. Trump actually reacted on social media saying Michigan has, quote, strongly and rightfully denied the desperate Democrat attempt to take him off the ballot. So what's the thinking for that legal decision and the other states who have sided with Trump on this to not disqualify him for January 6th?
This is a great example of how different state courts can arrive at different conclusions based on their own law and procedural differences. For example, in Michigan, there was no evidentiary hearing, and a Michigan Court of Appeals, the court below the Supreme Court, actually observed that they actually discussed the Colorado Supreme Court opinion. They said, well, look, that's a little different. They had an actual evidentiary hearing to decide whether or not Trump was an insurrectionist. We didn't have that here, so that is a distinction that has to be taken into account. The other thing is, but, I mean, you have the Supreme Court, the Michigan Supreme Court concluding, or excuse me, the lower court, Michigan Supreme Court just sort of adopted it, but you have that court in Michigan concluding that this may not be what's called a justiciable question. There's an issue as to whether or not courts can even hear this issue, or if Section 3 is something that is really committed only to other branches of the government other than the judicial branch.
justiciable, is that the word?
Justiciability and non-justiciability. Yes,
wow,
exactly.
Learn something new from Danny every day. Also want to learn something new on this. Special counsel Jack Smith yesterday filing that the motion in Trump's federal election interference case to try to block him from talking about the conspiracy theories and making political arguments during that trial. How will that play out, and do we think that Trump will abide by it?
Everyone knew this was coming. This is a major motion for the Jack Smith team, and it's really like a motion in limine. We make these motions all the time to try and prune the bonsai tree of trial before you get to trial, and this would be a major win if the government could get the court to preclude the defense from raising any of these political arguments. I'm being persecuted. The Biden administration is after me. Those would be central themes of Trump's defense. If they can preclude them and argue that they're simply not probative or relevant, then that's a huge win for the government.
Seems very hard to do to keep politics out of that.
Can't be done, I don't think.
Yeah, we'll see how it goes. Danny Cevallos, thanks so much.
Thanks for watching. Stay updated about breaking news and top stories on the NBC News app or follow us on social media.